I'll call the second case now, in re petition for reinstatement of Michelle MacDonald, and the record should reflect that Justices Chudich and Thiessen are recused from participation in this case.
May it please the court, I'm Michelle MacDonald. I'm here on my petition for reinstatement to the practice of law. The only question before you is whether the Lawyers Professional Board panel clearly erred in finding that I failed to prove moral change. My legal intelligence, intellectual capacity, fitness to practice law, my legal skills, my reputation, my honesty, my diligence, reliability, and good character are not in question. The responsibility for determining whether to reinstate an attorney rests solely with this court. In this case, I want to point out that the Lawyers Board panel adopted verbatim the director's findings of fact, conclusions of law, and recommendations. What that means in common sense terms is that the director wrote the panel's decision. This fact requires strict scrutiny of the court. As a lawyer, I've represented thousands of individuals before hundreds of judges for the past 36 years. I founded Family Innocence, a nonprofit dedicated to keeping families out of court, resolving conflicts and injustices peacefully. I have mediated for 26 years, bringing countless cases to resolution. I have had one client complaint in all of my years. This complaint comes from the director, and it's based on a radio interview that I was invited to participate in when I was campaigning for the Minnesota Supreme Court. 3 statements that I made violated the rules of professional conduct. First, my comment that Judge Knudsen in the Sandra Grazzini-Rucky matter violated the rights of parents by issuing a September 7, 2012 order without any hearing, without any process. The second comment is when I said that the crime was with the court when the judge did an order that neither parent could contact their kids. The third comment is when I stated that court orders are damaging people and families. There's a severe failure to follow the rule of law, to follow our Constitution and uphold it, and quite frankly, our civil rights are being violated by courts all over the state. Then in response to the interviewer's questions, asking whether Sandra Grazzini-Rucky case was one of those cases I was referring to of civil rights being violated, I replied yes. Fast forward to my hearing.
One of the things that just seems to jump out from the transcripts, or at least the parts that I read, and the reason the panel found in part that you had not demonstrated moral change is that in many of your answers to why you made the false statements concerning Judge Knudsen in that radio interview, you didn't seem to be able to articulate what was the root cause of that, or to be able to acknowledge that what you had said was false. And I think it comes out from some of the director's direct examination of you, but it really comes out when Mr. Rhodes was asking you, and the one question that I'm looking at, he said, why did it take a court order for you to recognize that the statements were false? Mm-hmm. So in other words, why didn't you recognize they were false on your own?
Okay. Well,
and I think that really gets at the heart of what mm-hmm. the trouble is here, is that you're saying, yeah, I recognize those statements were not true, but the only reason I recognize they're not true is because the Supreme Court told me they weren't true, that these were false statements, not just an opinion about, Judge Knudsen's work. That's fair game. But these were demonstrably false statements. But your testimony seems to indicate that the only reason that resonates with you is because we told you that.
No.
That's what I need to have you explain.
That wasn't my testimony at all.
Well, that's the impression you gave.
First of all,
that's the impression you gave, and so that's what I want you to clarify here now.
We don't have a subjective standard. I could have believed that those statements were true. That's not our law. We use the Graham standard. We have an objective standard here, not a subjective standard. So it doesn't matter. It matters. But I subjectively accept I didn't think they were false, okay? But the rules say that I falsely impugned the integrity of a judge. That's our rules. That's why I'm trying to explain the difference between morals in our personal view and morals when we're trying to follow the rules. I accept that rule. I accept that it broke the rule. But the objective standard is no reasonable attorney would have said that. That's the objective standard. No reasonable attorney would have said that. So that's what this court determined using the Graham standard, the objective standard. Some states don't use they call it like a constitutionally modified First Amendment standard, but we do. And that is why I defended myself, and this court, and I had a standing objection. You can't use the fact that I defended myself, and I think that's in much of the case law, to deny me reinstatement.
You understand the rule.
Absolutely.
But you disagree with the content of what you agree with the content of what you said, and you still believe that to be true, but you accept that we said it's a violation.
No, I broke a rule.
No, I understand that. You're saying you broke a rule,
right?
But you believe that what you said was truthful. You accept that you've broken a rule according to us, but according to yourself, you believe that it was true.
My subjective thoughts. I agree that proof of moral change is the most important factor under the court standard for evaluating reinstatement findings. Remorse and acceptance of responsibility are not difficult concepts. Petitioners often prove remorse and acceptance of responsibility by presenting evidence that the petitioner is sorry for or regrets the misconduct, or that the petitioner what did was wrong and that the petitioner took responsibility for the misconduct. I also want to say that when you compare September 2013 and Justice McKeague, read your dissent to my 60 days that I got for the 2013 behavior. I mean, I sued the judge for a federal class action civil rights lawsuit. I wrote 4 letters to the Board of Judicial Standards, which might not be so bad, but I basically sent them to a lot of the legislators, So that, in 2013, 9 years ago, compared to the comments on the radio station, that you can't even compare. You can't. I mean, it's comparable, but they act like it's, and I think I testified to this, they're like it's the same conduct. I said similar is not the same. So for this conduct, I got 4 months, which is turning into 2 years. And this is my petition for reinstatement. I have been disciplined, and this is my petition for reinstatement, that I will not do it again. In the words of Justice Tisson, okay, I only have 1 more minute, the director effectively insists that to satisfy the moral change standard, a petitioner must not only swear that he will abide by the rules of professional conduct, as we have interpreted them, this court, but that the rules, he must affirm that he agrees with how they are interpreted, the rules. The director's position is flawed. First, to protect the public and deter misconduct, lawyers need not agree with how this court has interpreted the rules of professional conduct, as long as the lawyer abides by your interpretation of the rule. And that's what I'm promising you I'm going to do. Requiring a lawyer to agree with the court's interpretation and so be constrained from expressing disagreement in my advocacy presents serious concerns under the First Amendment to the United States Constitution and Article 1, Section 3 of the Minnesota Constitution. There is no legitimate public protection reason for this court to require petitioners, again in the words of Justice Tisson, to prostrate themselves before this court in sackcloth and ashes and pledge fealty to our court's legal reasoning. Indeed, for public protection purposes, we expect lawyers in this state to do precisely the opposite when representing their clients. Thank you.
Thank you, counsel. Thanks to both counsel for the help you provided to the court in this case. This matter is submitted. We'll issue an opinion in due course. We're in recess.